660 AM. The Answer.
You are listening to the Wells Report. My name is John David Wells. Telephone number 866-660-5759. Title 8, Section 212F states, quote, whenever the president finds that the entry of any alien of any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation, and for such a period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Seems pretty straightforward to me, but there's so much more nuance and so much more. I mean, this is just mere English. This is one of the things that you have to be aware of, that even though the words seem clear, in a legal circumstance, they can be open to interpretation. And that's exactly what happened with U.S. District Judge Derek Watson. Probably spent most of the day on September 11, 2001, surfing while buildings fell down in New York, has no idea what real terrorism is about. He has no idea. And so he doesn't have any problem exposing the rest of the nation to a terror threat that first started with James Robart in Washington State and then filtered through the Ninth Circuit Court of Appeals and now has reached out to Hawaii, still part of the Ninth Circuit, of course, because if you're a leftist progressive, you have got to know how to get your legislation, which is not legislation, it's basically just judicial thuggery, through the courts, because that's the only way you can enact your agenda. Aside from that, I have no real problems with any of it. Joining us is Byron Henry. I hope you're not a leftist progressive, Byron. Please don't be infuriated with me. He is a Dallas-Fort Worth-based attorney and constitutional scholar. He has extensive courtroom experience at the federal and appellate court level. Also filed papers and briefs in the United States Supreme Court. Thanks very much for joining us, sir. Welcome to the Wells Report.
It's my pleasure, John David.
Like I said, I'm really kind of annoyed at this district judge. I mean, it seems to me that the law is clear for those of us, I guess, unwashed. Can you help us understand why it is that the law is not the law, at least in the mind of Judge Derek Watson?
Well, certainly. Well, first, let me clear one thing up. I'm neither a leftist nor a progressive.
Yay!
But I am a lawyer, and I do also play one on the radio. So
there you have it.
I'll attempt to walk you through this. But let me just say first, I thought that the Ninth Circuit decision affirming or denying the stay and basically upholding Judge Robart's decision in the first case was a stretch.
Yes.
The only reason I gave it legal credence is because the order itself had some ambiguities as to how it would apply to lawful permanent residents or people with green cards, which are a different class of alien than everyone else that the order affected. And because of that ambiguity, even though the White House clarified that it didn't cover those people, I kind of gave the court a pass on the fact that there was an opening there to sink your teeth into with some uncertainty with respect to the first executive order.
I completely concur.
The second one is more than a stretch judicially. At each level of the legal standard that they apply for a TRO, first of all, it's a very high standard. It's called extraordinary relief. You have to prove, that you were not just harmed, but irreparably harmed. You have to prove it is basically the highest level and most extraordinary relief to get a temporary restraining order issued in a federal court. So that's number one. But second, at each level, whether it's standing, which we're free to talk about if you want to, it's a little legalese, but who has the right to bring the suit, at the Establishment Clause level and the statutory level that you discussed in the lead-in, at all three of those levels, they have to reach to the extreme edges of jurisprudence with very little case law and apply doctrines that have never been applied. For instance, the Establishment Clause is not generally applied to immigration law, especially because it applies to people outside the country. The court here applied it just as if we had an Establishment Clause case down the street at your local city hall. Standing, they are allowing people to sue based on the idea that they might want to get a visa and come visit their family, but they weren't even required to apply for the visa and go through the waiver program that the new executive order puts in place for hardship, meaning you can't even prove that these people wouldn't be allowed to come to the country under the new executive order because they haven't even been required to go through the system under the executive order. And the most preposterous, I guess, is this idea that from these 6 countries, this very limited amount of people are going to somehow speculatively harm the tourism industry of Hawaii. Now, if you know anything about standing law in the United States Supreme Court, in federal court, you are not allowed to speculate that something might cause you harm in order to come to court. You have to prove what is called discrete and concrete injury before you can bring a case in federal court. So the idea that someone from Iran might want to apply for a visa and it might get denied, and enough of those people would get denied under this new program as to affect, from these 6 countries, to affect Hawaii's tourism industry, is not just a bridge too far. There is no bridge.
You're absolutely correct.
Basically,
It's completely preposterous. I can't see anything close to any kind of reality in this, except, of course, that Judge Derek Watson is hoping that when the great coming of the leftist progressive new way comes around, he'll be able to be the first justice of the leftist progressive kangaroo court. I don't know what else he could possibly be doing. This is very clear to me.
I believe the new order would have a hard time in the Ninth Circuit, and I'm stating that very little in the law is set in stone, by the way, because that's what lawyers do. That's the way the law is written. That's what lawyers are paid to do, or find avenues, find arguments, find ways to get in the door and get a good result. And these lawyers have done well to get in the door and to obtain this result, but I do not believe that even under a more liberal Supreme Court, with a 4-4 split, without a Judge Gorsuch, that there are 5 votes on the United States Supreme Court, including the liberals on the Supreme Court, that would uphold a decision like this, basically applying all these doctrines to the farthest extreme. I'll just give you one example. There's a statute in immigration law called the Lautenberg Amendment, which gave preference to Soviet Jews coming into the country under immigration law. Under this judge's ruling, the Lautenberg Amendment is unconstitutional because you cannot give preferential or negative treatment to any religion in other countries. That's just one. There are multiple laws on the books which deal with persecuted minority religions and asylum for religion, specific religions in specific countries that need help. According to this judge, every one of those laws are unconstitutional, even though they've all been on the books for years and years. So that's just one example of the overreach of not thinking of the consequences and applying this objectively instead of a political result, looking for a legal result, which is what the judge should have done, applying a political result, deciding the case before he ruled, and then trying to come up with a way to fortify it, and in doing so, it exposes the flaws in his reasoning.
Byron Henry is our guest, a DFW-based attorney and constitutional scholar. He has extensive courtroom experience at the federal and appellate court level. He has filed papers and briefs in the Supreme Court and can indeed argue cases in that high court of the United States. Counselor, okay, so we've covered standing. The thing that bothers me, there's another thing that bothers me about this, is that our Constitution is being interpreted as for all times and all people. In other words, it's not just for Americans, and I'm trying to differentiate between some guy who shows up on an aircraft in from Paris, a Frenchman who shows up from Paris, and whether he has the same rights as an American citizen as I do. I mean, and if so, why is an American citizenship more valued in this country? It seems to me that I pay an awful lot of money for it. I would sort of like to have some sort of privilege that doesn't exist elsewhere.
Well, certainly American citizenship matters, and there is a doctrine under the Due Process Clause that applies to individuals in this country, whether they're here legally or not. The Supreme Court has said so, that people here in this country legally or not have certain rights. They don't have the same rights, but they do have certain protection. But what we're talking about here are people outside the country with no legal connection to the United States. They have no right to travel here. They have no visa. They have no papers. They have not even applied for a visa. They haven't applied for a waiver. They may have a relative or a friend, or they may want to vacation here, or they may want to go to school here. Maybe they even want to come here to get a job. But they have no constitutional or statutory rights to be in the courts. So what they're doing is they're getting people from here that know these people, are related to these people, and saying, well, my son-in-law won't be able to come visit me because Trump is anti-Muslim and his travel ban keeps him from the country. And the bottom line is the Supreme Court has said a long time ago that all a person is due all the process a person outside the country applying for a visa is due is notice from the consular office that your visa has been approved or denied. That's it. A one-sentence letter is all they get. So if you can deny someone's visa discretionarily at the consular level overseas, there's no way that a federal court is going to allow the mother of that person to sue from in the country and ask a court to order that he be allowed to come into the country. And that's the ridiculousness of this whole thing is that these people haven't even tried to come into the country.
Yeah, they
saying
have done
that
anything.
this travel ban is going to keep me from the country, and I don't even have to prove that I tried to come. I don't even have to show you a visa application that said I tried to come to the country legally or applied for a waiver, which is, like I said, that's not even a stretch.
I mean, it's incredible.
That is almost unbelievable that a court would buy that argument. Now, the real, and one problem you haven't even mentioned yet, is this idea that because Trump made, as a citizen and as a candidate, some statements about radical Islam and Muslim countries exporting terror, that because he made those statements, any action he takes against a country that is majority Muslim is going to be basically de facto considered a religious discrimination. And that's basically what the court is saying. So it'd be interesting that if we decided to send troops into a country, or President Trump decided to actually use a drone attack, would he allow the ACLU, would this judge allow the ACLU to get a TRO, stopping President Trump from taking military action against majority Muslim countries because it's religious discrimination?
It doesn't,
according to the judges.
There doesn't seem to be any kind of a gate. There does not seem to be any kind of a door to close where the president picks up from where the court leaves off. It's very dangerous to me.
It's almost as like for 4 years, President Trump is not to allow, his administration is not allowed to take any action because of some off comments and out of context statements, by the way, taken by Rudy Giuliani and a couple of his speeches, basically are proof positive that anything he does with respect to countries or anybody that has any connection to the Muslim faith are de facto unconstitutional for his entire term. First of all, that's not the law, and it can't be the law because the president, the court has said that a president is acting with the most power he has under the Constitution when he's acting in his national security position with a grant of power that you read from Congress. When those two things combine, the courts basically have to defer to all but the most ridiculously inane, unconstitutional policies. They basically have to tell the judge if there's any rational reason to allow this to go forward, we have to allow it. They have to defer to the president. And you have seen no deference in any court decision since he's taken office to President Trump as the President of the United States and the Chief Executive and Commander-in-Chief of the military.
You see, I don't have any problem whatsoever with the Establishment Clause. I got all that. But you know what? The Establishment Clause is not a suicide pact. And this is ridiculous and stupid. We're at war. And we need to understand that we're at war. And I suppose it's far too much of a stretch to hope that the District Judge Derek Watson ever understands we're at war. So let's move forward to the Ninth Circuit. Do you believe the Ninth Circuit will uphold this TRO?
Well, it depends on, first of all, whether or not what panel they get. I don't know if you saw today that the Ninth Circuit decided not to vacate its original very lax and, I believe, poor opinion on the first stay. The three-judge panel did not vacate its decision, but there was a dissent by like 6 or 7 conservative judges on that circuit that basically said that this policy was well within the president's powers.
Right.
It's not perfect, but we have to give deference. So if the president gets a panel of judges, for instance, that has 2 moderate to conservative members, I believe they'll get the votes to overturn the TRO or get a stay or otherwise overturn any injunction. But if they draw the majority of the Ninth Circuit are more liberal judges, more, I believe, ideologues from the progressives or liberal side, we could be looking at another en banc for the entire court to look at, or going to the United States Supreme Court in short order.
Well, we're going to have to do something. Byron Henry, thank you so much for your time. If people want to know more about you, how can they get in touch with you?
I'm on the internet at www.solidcounsel.com.
Solidcounsel.com. Byron, we're keeping your telephone number. We're gonna call you back and try to get some more information about that as this unfolds, because I don't know about you, but I just can't put it past the Ninth Circuit to screw up this decision, to be cleaned up yet again by the Supreme Court of the United States. I agree with you. I'm reasonably sure that even Elena Kagan would rule in the favor of the president on this one, certainly on the second EO, the executive order, if not the first. And, President Trump said today in Nashville, he said, I think we should have fought out the first one. I think we should have taken it all the way to the Supreme Court because the clock is still ticking, and people from these 6 countries are still coming to the U.S.